Welcome everyone. My name's Kelly Walters. I'm a family solicitor specialising in children and financial settlements with separating families. I've dealt with family law since 2003, and I would say over the recent years I've come to acknowledge more the real benefits of mediation. In 2019, I joined Concilia Legal to train as a family mediator. So I currently spend my time doing both legal and mediation work. And having completed the foundation course, I'm now working towards accreditation. Some of you may or may not be aware that it is Family Mediation Week this week. This is organised by the Family Mediation Council, and essentially is to raise awareness around mediation. So this week, so far as topics are concerned, we've looked at domestic abuse, we've looked at children and how different mediation models can assist professionals. And today, the topic for discussion is resources. So I would encourage all of you to access the Family Mediation Council and CAFCAS website. It offers great tips to families. So today I have Kieran Conlon, my colleague, joining me, and we thought it would be beneficial for Kieran to put some basic questions together for people who don't really know much about mediation, and they can learn about the process, what's involved and so forth. So Kieran, please fire away.
Of course. So we put together a list of the 5 most commonly asked questions that we get at Concilia. So we're just going to run through those for everybody. So the first question we always get is, what is a MIAM? Okay, so a MIAM, it's called a Mediation Information Assessment Meeting. So this is the first stage of the mediation process, and the aim of the meeting is to try and find out if mediation is suitable for you. It's an opportunity for you to meet the mediator and of course to ask any questions about the process and also to discuss the issues in your case. Traditionally, we would see you together at the office, but of course you can meet separately. If we deem that mediation is safe and appropriate, we would organise a joint session, but mediation is of course completely voluntary, so both parties must be willing to engage. If the mediator, if I, for example, deemed that mediation wasn't suitable in your case, I would give you a court form, and that would then provide you with the opportunity to make an application to the court, whether it be for financial relief or children matters. Brilliant, thanks Kelly. So the next question we have relates to a lot of our clients may be anxious about beginning mediation, especially if the relationship has took a wrong turn and they're not on great terms with their ex-partner. So another common question we get is, if I'm coming to mediation for a joint session, do I have to sit in the same room as the other party?
Okay, so of course we've all been hit by COVID-19. So over the past couple of years at Concilia, all our mediation has been taking place on a video platform. So we have been carrying out our mediation via Zoom calls. And of course we can do this on a shuttle basis. So what that means is that we would put one of you, well, both of you, in a holding room, and then I, as the mediator, would go between you both, and that way you don't have to see the other person. Discussions can continue. It may take more time, but of course if you feel more safe that way, then we can arrange it. But if you do feel comfortable having a joint session, that's fine.
Excellent. And in terms of whether the clients then reach an agreement at the end of mediation, is the agreement that is reached legally binding?
Okay, so mediation, no, it's not legally binding. And also, whatever you say in mediation, you cannot rely on that during the court process or indeed in court. If you do reach an agreement, the mediator can draft something called a memorandum of understanding. So this document sets out what you've agreed, whether it be in relation to the children, who's spending time with the children and when, or who's going to get the house and so forth. And you can take that agreement to your solicitor, and the solicitor can then take steps to make it legally binding.
Excellent. So we all know that generally one of the main benefits of going to mediation is it is quicker than going through heavy litigation and into the courts. But on average, how long does mediation actually take as a process?
Okay, so it does depend on the complexity of the case and the issues, and to some extent the relationship between the parties. But in general, generally, you'd be looking at maybe 2 to 3 sessions of maybe 90 minutes to 2 hours each. So the number of sessions will determine how long the process takes. At Consilia, we are flexible, so we can work around you and your availability.
Excellent. And then just to round off, what are the main benefits of entering mediation to resolve any family dispute?
Okay, so as a solicitor, I'm very familiar about the time and, more importantly, the cost implications of making an application to the court. A typical court case can take 6 months onwards, and of course this is not in the best interests of either parties or especially the children. And what I would say is that you don't want a stranger making decisions about your family, your children, or your financial future. If you engage in mediation, you can make your own decisions. The mediator can help you develop those options, and then both parties are the decision makers. So in a nutshell, speaking from a solicitor's point of view and also a mediator's point of view, mediation is definitely the right way forward to begin with, rather than jumping in to the court process.
Excellent. Okay, everybody, so that rounds up this very quick Q&A session. So those were just 5 generic questions that we're commonly asked at Consilia. Obviously, if there's any questions you've got that we haven't covered, feel free to get in touch or stick them in the comments section below, and we'll answer them and get back to you as soon as possible.
Super. Thanks, Kieran.